candidates. Let me ask them to, my colleagues to introduce themselves first.
Yeah, my name is Dilvinder. I'm a trainee from the High Court in Berlin. And the past 3 months I was interning at the SOAS Vienna Moot. It's a pleasure to have you here.
Good afternoon, my name is Jerrick. I come from Georgia. I've been here as a coach 6 years now. I coach at the State University. I've been a student before myself. Good luck.
Thank you. And my name is Jim Miller. I'm formerly a judge in the United States, and a trial judge in Colorado, the state of Colorado. For the last 6 years or so, I've been a panelist arbitrating and mediating cases with JAMS, which is an international arbitral institution. This is my second year there, and I'm just, with each round, more impressed with the level of competition and poise that you all display, and I wish you luck as well. I'm sure we'll see exactly that. Let me ask first, is there any agreement between the teams as to how you'd like to proceed in this round?
Yes, we agree that the respondent will start first, challenging the jurisdiction, followed by the claimant. Then the respondent reserve 1 minute for rebuttal, followed by the claimant, reserving time for rebuttal. Then we start on the merits, followed by the claimant, which will address 1 minute for rebuttal.
That's fine. Great.
Thank you. The respondent has 2 points to make on this rebuttal. Firstly, as Mr. Arbitrator correctly stated, the right to be represented is not an unlimited right. Not only claimant has no right to subsequently amend the tribunal in a fashion to imperil the tribunal's status or legitimacy. Respondent submits that the claimants acted in a breach of Article 9 of the CFAC arbitration rules that states that a party has a duty to act in a bona fide cooperation. Secondly, nowhere in the case stated what is an actual governing law of the lease contract. Thank you.
So you actually say that they acted in bad faith?
Excuse me?
So you actually, you're actually submitting that the claimant acted in bad faith?
In breach of bona fide obligation.
Mr. Lin?
Will we be allowed for a rebuttal?
Is there time remaining for that?
We actually had 2.5 minutes left on our time.
I thought so, and if the panel is agreeable, we'd like to hear that, Mr. Lin. Thank you.
Thank you very much, Mr. Arbitrator. Now, once again, we will submit that the obligation to disclose is in fact on the arbitrator and not on Dr. Elizabeth Mercado. Our appointment of Dr. Elizabeth Mercado was not made in bad faith. She was merely the most qualified person to sit on our legal team. And we are puzzled as to the respondent's second submission because under claimant's exhibit number 1, paragraph 15.2, it states very, very explicitly, this contract is subject to the law of Mediterranean. We have no further submissions under rebuttal. Thank you.
Anything else on those issues for either side? We'll proceed then to the merits, and forgive me, Mr. Summers.
The respondent will raise the Article 79 exemption first.
I'm sorry. Counsel?
Good afternoon, Mr. President, honorable members of the tribunal. My name is Mikhail Zaporozhkin. As my co-counsel already mentioned at the beginning of her opening speech, I will address the issues regarding the exemption of the respondent from liability. Mr. President, honorable members of the tribunal, it is undisputed that the respondent breached the contract which was concluded between the claimant and the respondent. However, in order to claim a person liable, there must be breach of the contract, which is undisputed, and also not applicable any exemption. However, to this particular case, it is respondent's submission that respondent is exempted under the Article 79 of the CISG Convention. Under CISG Convention and Article 79, respondent or party may be exempted in 2 situations. There's the paragraph 1, which deals with the breach of the obligation when the party itself breaches the obligation, and the paragraph 2, which deals with the situation when there is engaged a third party to perform part of the contract or whole contract. The paragraph 2 applies to our present situation, as far as the respondent engaged specialty devices to perform part of the contract. Specialty devices, therefore, is a third party, because the third party is to be understood within the scope of the paragraph 2 of the Article 79 as an economically and legally independent person from the obliged party. And therefore, paragraph 2 is applicable to the present case. Because of the fact that the specialty devices is regarded as the third party, the conditions set forth in the Article 79, paragraph 1, which constitute the exemption of a party, must be fulfilled cumulatively, also by the third party, which is specialty devices, and also by the respondent itself. According to the first paragraph of the Article 79 CISG, there are 4 conditions that must be fulfilled. Firstly, it is an existence of an impediment. Secondly, the impediment must be beyond the obliged party control. Thirdly, the impediment could not have been reasonably foreseen by the time when the contract was concluded. And finally, it is the 4th condition, that the consequences of the impediment could not be avoided or overcome. Firstly, the respondent would like to deal with the first condition, the existence of the impediment. Impediment, within the meaning of the Article 79 CISG, is a circumstance which objectively prevents the party to perform. In this present case, the impediment is impossibility to obtain the chips on the market worldwide. This impediment began at the moment when the technical solutions obtained the chips and refused to sell the chips even for a higher price to the specialty devices. Specialty devices, as a third party, at this point, had no other option how to obtain the D28 chips. And this impossibility to obtain these chips in any possible manner constitutes an impediment within the scope of the first condition.
Isn't procurement risk a risk which a seller undertakes normally?
Normally, yes, but this is not a standard situation because impliedly a claimant chooses the D28 chips for these systems, master control systems. However, the agreement between the claimant and respondent was set for a performance. There has to be some performance achieved by the master control systems. However, pardon me, as it is stated on the page 47 in the paragraph 12, there is stated that such qualities as the D28 chips offers could not be achieved by any substitute chip. It is clearly stated that even if the substitute chip would be used, no guarantee of comparable performance given the unique qualities of D28 chips could be achieved.
Doesn't it put an even greater risk on the seller, the risk of procurement or being unable to procure?
It is the respondent's claim at this point that part of the risk of this breach of the contract is on the claimant, because the claimant impliedly chooses the D28 chips as the providers, as the part of the obligation. It is respondent's.
And it's implied because?
It is implied because the performance, which was contracted between the parties, according to page 46, paragraph 5, this performance could be achieved only with the D28 chips. Therefore, there could not be any substituted chips which would achieve such a performance that was contracted between the parties. With regard to the second condition, the impediment was beyond the respondent's control. As it was previously stated, beyond the control means that the impediment is of an external character. And it was clearly stated that the specialty devices could not obtain the D28 chips in any manner possible, because they were simply not on the market and they could not be obtained by any manner. And therefore, this impediment, which is of external character and cannot be controlled, is fulfilling the conditions set forth in the second condition. With respect to the third condition, the respondent could not foresee that there would be such impediment, that the obligations towards the third party will not be fulfilled, that the contract will not be performed, not because the not because of the fire, which was at the beginning of the whole chain of events, but that the manufacturer of the chips, on his sole decision, sold the whole package of the left chips to another party, Technical Solutions, and the Technical Solutions refused to sell the chips for an even higher price to the third party. This could not be foreseeable, as its respondent statement. With regard to the fourth condition, and it is...
Excuse me, Councillor, to stick on that point, wouldn't it be possible to go in a contractual way with, I mean, it was it's your partner of contract, it's not the partner of contract of the payment side. So it's your duty to take care of your partners of contracts.
That is, of course, true. But even if the respondent would enter into contract with any other supplier, any other supplier would also have to use the D28 chips. And there were no other supplier. The specialty devices had an impediment which was not only regard to them, but it was global. Therefore, there would be no other option with another supplier, nor with another product, because the D28 chips, as was argued a few minutes ago, could not be substituted by any other chip. And the respondent would like to move to the argumentation with regard to the fourth condition, and it is that the consequences of the impediment could not be avoided or this is clear that the specialty devices attempted or made the attempt to overcome the impediment by contacting the Technical Solutions and asking whether they will sell them D28 chips for even a higher price, because it was very important. And when the Technical Solutions refused, all possible solving of the situation ended at this point. And also, I would like to get back, no substitute chip could be used or couldn't be used, nor any other supplier. Therefore, the consequences could not be avoided nor overcome. As was proved before that these four conditions apply, all these four conditions, which are applicable as to the specialty devices and also to the respondent itself, because this is formed by the one and single even chain of events, and therefore these four conditions, as was stated or argued now, are applicable to both parties. By concluding the argumentation, it is the respondent's position that all four conditions set forth in the Article 79 of the CIG were fulfilled also by the respondent and also by the third party. And therefore, the respondent should be exempted from his liability.
Thank you. Any questions from the panel? Mr. Sandovan, if you'd like to proceed.
Good evening, honourable members of the tribunal. My name is Dilvinder. I'll be presenting the argument on the merits of payment. The claimant has three submissions. The first submission is that the respondent's late delivery breached Article 33, subsection A of the CISG. The second submission is that the respondent is not entitled to the Article 79 exemption. And the third submission is that the losses suffered by the breach of the respondent should be awarded as damages under Article 74 of the CISG. Moving to my first submission, the respondents do not contest that they delivered late. This is shown by paragraph 24, subsection 4 of their request for relief, where they state that they delivered late. Also, under Article 33, subsection A, it is stated that if there is a fixed and terminal date and this constitutes, and this is not performed by, this constitutes late delivery, and therefore the respondents have breached the contract where the contracted delivery date was the 12th of November, and they did not deliver till the 14th of March, several months after the contracted date.
I don't think that the breach is disputed.
I'm just about to move on to my second submission.
Before you do that, Mr. Sander, just for argument's sake, I've heard the argument advanced in a very similar case, that by accepting and ultimately paying for the lease, it was the lease, right? You waive the breach. Is there any for argument's sake, any response to that?
Regarding this payment was made by a letter of credit, and under international policy, a letter of credit can only be revoked if there has been fraud, and therefore the payment could not be stopped by the claimant.
Thank you.
Thank you. Now moving on to my second submission regarding Article 79. As stated by the respondent, there are 4 conditions for Article 79 to be applied. The first is that there has to be an impediment present. It has to be beyond the control of the respondent, and it has to be unforeseeable, and reasonable steps have to be taken to avoid the impediment. Regarding the impediment, first of all, Secretary and Swenza and also Hoover state that a impediment is a natural disaster such as an earthquake, hurricane, or a war, or terrorist attack, or a transfer embargo by a government. An impediment such as not having distribution of the chips is not akin to a natural disaster.
How about fire?
Fire is also not akin to this. As can be shown, a natural disaster is much more of a substantial event than a fire localised in a factory.
Why do you suppose that distinction exists between, for instance, an earthquake or tsunami on the one hand and a fire on the other?
I actually like to refer to the 1978 draft of the CISG commentary, which states a fire can be an impediment. And this strengthens the claimant's argument because under the modern 1979 CISG, a fire cannot be considered an impediment, as all the commentaries do not agree with this, and they do not state fire as an impediment. Therefore, an impediment cannot be found in fire or lack of distribution, as it's not akin to such a natural disaster. Moving on to my third submission regarding losses suffered due to the late delivery by the respondents.
Before you move to that submission, if I may have a question. As far as I understood from respondents, they mentioned that the impediment there was not really a fire, but a failure of the supplier. Could you respond to that argument?
Yes, a failure by supplier is not akin to such a natural disaster, as already previously stated. And also, there was not a failure of the supplier. As exhibit number 3 states, the high performance was still able to deliver on a pro rata basis, or on a basis where they would supply to the customers that required the least chips. The respondent and specialty devices in this case did not try to contact High Performance, the actual producers of the chips, to try to negotiate. Instead, they waited for High Performance to sell the chips and then contact another company that had a use for the chips. Therefore, it was not reasonable not to contact for High Performance and contact Technical Solutions.
Is there any obligation or anything in the law or the rules that apply to this case that would dictate how High Performance, the actual producer of the chips, should have distributed those after the fire, the ones that remained after the fire?
Regarding this, the claimants accept that High Performance is not a third party under the Article 79, as it was not directly engaged. And the Iron Molybdenum case states that where a supplier or a sub-supplier does not perform its contract, the respondent in this case can be liable for the failure of the supplier. If there are any more further questions, I'd like to move on to my third submission regarding Article 74 and damages. Article 74 sets out that the damages have to be foreseeable and they have to be reasonable. In this case, the chartering, there will be 4 heads of damages, and the first head of damage is chartering of a substitute vessel. The second head of damage is the brokerage commission, and the third head of damage regards the success fee, and the fourth head of damage regards the ex gratia payment. Regarding the first head of damage, the lease for the substitute vessel, the MS Pacifica, this is foreseeable as a reasonable person in a reasonable third person in the respondent's shoes would realise that the claimant would need the vessel as they run a conference servicing company.
But the contract actually was not for a vessel, the contract was for control systems. Would it be foreseeable that the need would be for the control systems and not for the whole vessel?
The control systems were a vital part of the vessel, as can be shown by paragraph 5 of the facts that my apologies. The MS VIS was meant to have the latest conference technology and cabin technology, and the master control system was vitally important to this.
The question is that I have is that when faced with breach, your client went directly to substitute the whole vessel. Did your client ever explore any possibilities for substitution of the control systems, which maybe could have been installed on MSVs, and then there would not have been a need for another vessel?
The claimants contend that it was respondents' duty to try to look for a substitute master control system. As the contract states, the D29 chip was not crucial, and as shown by paragraph 5 of Procedure Order Number 2, Annex 1 regarding the specifications did not only primarily related to performance and did not actually mention the D28 chip. Therefore, the respondents may have been able to procure another chip and be able to supply us with the master control system.
Should we take it there, even if we take it there and breach, isn't it an obligation to mitigate the loss? And I'm just wondering whether your client acted in the most reasonable way faced with breach.
Regarding this, regarding mitigation of losses under Article 77, the claimant did act reasonably, as corporate executives was a long-standing regular customer and had an annual conference, and therefore by providing a vessel that was not of the same calibre as the MS VIS was going to be, would detriment our relationship with them and any future clients, as we would not be able to provide the service that was intended. That also relates to the foreseeability of the chartering of the substitute vessel, and the chartering of the substitute vessel was reasonable, as the vessel was needed for the corporate executive's contract, primarily because we would have to cancel the contract if we weren't able to procure a substitute vessel, and cancelling the contract would create further losses for us, and further losses that the respondents would have to pay. Therefore, it would mitigate losses under Article 77. Moving on to the second head of damage, regarding the broker's commission. As the chartering of the substitute vessel is foreseeable, the broker's commission was an ancillary payment to the chartering of the substitute vessel, and therefore can be foreseeable in those circumstances. As stated by the facts, the broker's commission was a standard 15%, and this in this regard is reasonable as well, as it is the standard market rate that has been paid. Moving on
to where does it state that 15% percentage? Sorry, it's too picky, but
it states on paragraph 18, page 7, 4 lines down, the standard brokerage commission was 15% of rental costs.
Okay, thank you very much.
Moving on to the third head of submission regarding the success fee. The success fee in this situation was paid to an independent contractor to help us procure the vessel, and in this situation, as stated under Procedure Order Number 2, the broker found it very difficult to find a substitute vessel that was similar to the MS VIS, as it was going to be of high standard, and we cater for very demanding clients. Therefore, this payment was needed so that we could procure the vessel as quickly as possible. So if we did not manage to procure the vessel, then we may have to cancel the contract with corporate executives and incur further damages.
Counsel, I have a question with respect to that success fee, and completely apart from how we might characterize it as legal or illegal, and even assuming payment by your client of a success fee is foreseeable under the circumstances. How do we assess the amount of the success fee? Again, it's kind of a clumsy question, but while the fee itself may be foreseeable, it seems like there's no way to predict the amount of the success fee. And does that render it unforeseeable?
Regarding this question of reasonableness over the success fee, in this situation, we may not have been able to procure the vessel without such a success fee, and therefore we would have to cancel the corporate executives contract in incurring more loss, and therefore this small payment helped us procure the vessel, which in a situation we may not be able to procure otherwise.
Should we simply give you a blank check to pay that success fee in any amount that might be demanded?
In this situation, the success fee was agreed before the chartering leasing of the MS Pacifica, and therefore it was pre-agreed before we had actually chartered the vessel. Therefore, that payment was foreseeable and reasonable. Moving on to the fourth head of damage regarding the ex gratia payment. This can be foreseeable, as without this payment, we may have loss of reputation, and particularly this relates to the MS Pacifica not being of as appropriate and suitable standard as the MS Vis was. This is shown in Procedure Order Number 2, Question 20, where the corporate executives raised concerns over the MS Pacifica. They stated that it was appropriate as a vessel, but however it lacked some of the features that the MS Vis had.
Did they ever request that payment?
They did not request the payment, but as the Art Books case states, a voluntary payment can be substantiated and seen as reasonable.
How did you calculate whether it should be 120%, 20,000 or just 20,000?
This payment, probably will just give you a moment to view Procedure Order Number 2, Question 20. The facts do not actually state whether this was considered to be what percentage and whether it can be foreseen in that circumstance. But it can be foreseen because without this payment we may have lost future business through corporate executives. As already stated, they were a regular client of us and held an annual conference. And not just relating to the corporate executives contract, but generally, as a conference service, our reputation is very of importance to us. And therefore, if our reputation is damaged by not being able to provide such a high standard that our clients and future clients have become as accustomed to, would create more substantial loss in the future. Therefore, I'd like to conclude by stating that in the prayer of relief, we state that the payment should be awarded damages in full, and awards and cost of interest for the arbitration should be awarded as well. If there's any more questions, that ends the submission for the payments.
Any questions about that? Mr. Senator, thank you.
Thank you.
And Mr. Zagoreski, well, how much time do you have remaining, sir?
Excuse me?
How much time do you have remaining?
4 minutes and 1 minute for rebuttal.
Okay.
Thank you. The respondent will now deal with the damages. And the claimant raised issues on the 4 points. Firstly, it was the chartering vessel, then commission fee, success fee, and expiration payments. The respondent would like to bring into the tribunal's attention a very important fact. According to pursuant to the Article 74 of the CIHG, and also Mr. Saido, who's legal expert in the field, whose opinion should be considered in the interpretation of law, states that the knowledge obtained at the moment when the contract was concluded is the only relevant fact for the foreseeability of the damages. Our learned colleagues representing claimant stated that according to the paragraph 5 of their application to the arbitration, they stated that the claimant wanted the best equipment for the conference. However, according to the statement of defense of the respondent, they stated that the respondent had no independent knowledge about this information. Therefore, this was not known to the respondent at the time of the conclusion of the contract. Chartering a vessel, and also with regard to the commission, or in conjunction with the commission, could not be foreseeable. Because according to the page 47, paragraph 14, there is clearly stated that respondent obtained knowledge about the conference of the corporate executives on the 5th of August. And it is almost 3 months after the conclusion of the contract. This is the clear evidence that the respondent had no knowledge that executives, this company will have the conference held on the MS Swiss.
Does it know that the vessel was needed for conference services?
Of course, the conference services, it was clear to the respondent that, that the claimant is preparing these conferences. However, there is also difference between the clients. And the corporate executives is one of the best and the top of the clients. With regard to the commission fee, it was also stated by the claimant that it is a standard fee. And the legal representatives of the claimant pointed out to the paragraph 80 of the claimant's submission, or statement for application. But again, the respondent would like to state that this information, according to the statement of defense, paragraph 1, was not known to the respondent in time of the conclusion of the contract. It was stated by the legal team representing claimant with regard to the success fee that it is a small payment that helped to procure the ship. This is clear that when the claimant approached the broker, according to the page 4922, was promised success fee after he located the ship, MS Pacifica Star. Therefore, the argument that the broker had a very difficult time locating a ship is not applicable here, because the success fee was promised after the ship was located. And it is most important to stress out that the success fee was promised even before the broker attempted to enter the lease contract. The broker just reported the information that there is a ship, and without even trying to lease the ship, he was promised a success fee. Therefore, the argument that the success...
Excuse me, Hans, isn't it normal, like, having a broker and he's for it, and then that's his job? So how do you judge how much effort he has to put in his job?
The respondent would understand and would have no objection if the broker first tried to agree or to enter into the lease contract, make some effort to enter into the lease contract, and even if it will not be successful, then the success fee would be appropriate. But before any attempt made, it just cannot be foreseeable to the respondent. Honorable Tribunal, I see I have run out of time. I would like to ask for 1 more minute so I could finish and conclude the arguments.
Any objections to the pen? Or yes.
Last is the ex gratia payment. According to Mr. Dilvinder, in his commentary on CISG Convention, it is clearly stated that voluntary payments, which ex gratia payment is, generally cannot be considered as foreseeable. Ex gratia payment also has no clear system or method of calculation. Therefore, it was not proved sufficiently by the claimant how was this price mitigated when there is no clear form of the calculation. Concluding aforesaid arguments, it is the respondent's submission that the claimant is not entitled to the damages as far as the conditions set forth in Article 74 of the CISG were not fulfilled. And unless there are no questions, I thank you for your attention.
Counsel, thank you very much, Mr. Sander.
The claimants are reserved 1 minute for your question.
Yes, thank you.
The claimants have 2 submissions. First, regarding foreseeability of the substitute vessel. As a commercial entity, the claimants would not allow their vessel to lie around in wait from between November till March, not in use, when it's their flagship event, it's their first yacht that they've had of this type. It's meant to be their main drawing factor for clients. Therefore, it would be foreseeable that we would need a use for this yacht. And regarding the success fee, I'd just like to clarify for the tribunal, as the respondents may have been slightly misleading. Procedure order number 2, question 21, actually does state that the yacht broker did have a very difficult time in locating a vessel. And then question 22 is regarding the MS Pacifica, where it was where the broker stated that he had found a vessel, and the claimant said that they wished to procure this vessel, and that's why the success fee was paid for acquiring the MS Pacifica. As procedure order number 21 states, he had a very difficult time in finding a vessel. And also, Mr. Goldrich did not normally lease his yacht, and he has done so on very few occasions. Thank you. That ends the rebuttal for the claimants.
Is there anything else for I to say?
Respondent has only one point to make very short. That it was not foreseeable to the respondent that the claimant will charter MS which was not even prepared at the time of the conclusion of the conference.
Sandra, anything else?
No, thank you very much.
Anything else for the panel? Would you like to excuse everyone for a few minutes? We're going to do, I think you've all been through this kind of standard procedure. We're going to excuse, thank you all very much. It was very enjoyable. Thank you. I say that right up front. But can we excuse all of you now for just a couple of minutes, and we'll confer and we'll step out and get you when we're ready. Thank you very much.
Thank you very much.
We have a right to our counsel of choice. It's a little more difficult, but I think which makes it even more worthwhile to think about, and I think you did. When you've admitted you're in breach, that's a bit of a hole you have to dig yourself out of, having admitted the breach, and I think it's great that you admit it. So how do you argue to us that nevertheless, just as a matter of fairness, you shouldn't be held responsible for all of that, or some or all of that ex gratia payment, or the success fee? You know, what are some really, I don't know the answer, by the way, I'm great at asking questions, but I have no answers. How can you argue to us that, notwithstanding you breached the contract, it's just unfair for us to have to pay everything the claimant is asking for, even if we assume that it's not bribery, or even if we aren't particularly troubled by the bribery, if it was bribery. It's still, geez, is it a blank check that we're having to write to the response? But I think if you think in those real world kind of fairness terms, how do we strike the balance one way or the other? But I was just so impressed with the authenticity that you all brought to this, the feeling of authenticity. I think that's terrific. You both do well in competition. You're all going to do well in practice. You're already there. Congratulations. Thank you.
Thank you.